politically speaking with me, Tarun Nangia. We commence the part 3 of our discussion on PMLA in light of the order of the Supreme Court, namely given by Justice A.S. Bopanna and Justice Sanjay Kumar in the Basant Bansal Pankaj Bansal case, where they have laid out a very, very important directions for the Enforcement Directorate. The direction being that it is mandatory to supply grounds of arrest under PMLA by the Enforcement Directorate before they arrest someone. This is a landmark in a direction. This will go a long way and implement so many cases. I have somebody today as my guest who has appeared for Basant and Pankaj Bansal in the Supreme Court, also in Chandigarh, where there is some other matter against them. Somebody who's a very well-known name in the field of PMLA, financial crime cases, but especially PMLA in the recent years. You would have seen his name in many other high-profile matters also. But today we limit our discussion to this case and the implications. I would like to welcome Advocate Vijay Agarwal. Good to see you, sir.
Hi, sir. It's always a pleasure being with you.
At the outset, give me a 2-minute opening comment on the importance of this order that was authored by Justice A.S. Bopanna and Justice Sanjay Kumar in the N3M case.
See, it is being pitched as something very new, and I would say that it is a new wine in the old bottle. It is basically the reiteration of the Madhu Limier principle. It was first laid down in Madhu Limier. See, it is nothing new with this. Section 19 is nothing new. It has already been there in Section 50 CRPC, and it is already there in Article 22 Constitution of India, that you are going to inform the person the ground of arrest. Then there was a judicial controversy. Delhi High Court 2 division benches. Justice Muralidhar's bench said that inform means you have to supply. And then the Justice Vipin Sanghi's bench in Moin Qureshi said that inform is only inform. Then when this Senthil judgment came, we were all very happy, but because it used the expression served, right? But then it again gets, then it was again argued in the High Court. The ED has a panel of some great lawyers. Then there is one very good lawyer from the ED side who appears, Mr. Zoe. He brought out a lot of dictionary meaning of the word serve. And he said served is again informed. So again, then there was a judicial controversy, which has now been set at rest by this judgment. But there were 231 old judgment also, which say that in case an accused comes and says that he has not been furnished the ground of arrest, then the onus of proof is on the department. So now it has gone a step ahead, and it says, so iPhone 15 is going to be better than i13. So when there's something new, it is to be better than the old one. So the new feature in this judgment is that it also says something very beautifully. It says that, okay, let us assume that you told or you informed the ground of arrest to the accused, but the moment you tell them that that he is being arrested, after that he will lose his calm and his peace of mind and his rationality. So that time, these 6-7 pages, is he going to remember to brief his lawyer? Will he be able to understand? And he may not be a person of a legal bent of mind. So that is why it is always safe to furnish him the ground of arrest in writing. So that's the change. And they say that the ground, it is going to be illegal. Now, so when you will speak to various councils and, people have been talking, this is a judgment on that, people should be released. No, it goes a step further. This is what I am doing in my cases, that now in whichever cases these grounds were not furnished beside illegal arrest. Now when the complaints against them are filed, so the investigation which happened thereafter, when the clients were in illegal custody, their statements recorded and investigation done thereafter is illegal. They are the fruits of the poisonous tree. So that evidence cannot be read. Though in India, this law has not been much applicable, there is a whole line series of judgment that even the illegal investigation is the material collected in the illegal investigation can be used. So it is on the principle that the end would justify the means. So, but no, now there is a judgment Selvi also, which says if you permit the police to use the illegally collected evidence. So pursuant to illegal investigation, illegal arrest, you take the statement of a person. So can you use that? Selvi says no. It is a 3 judges bench that it says that no, if you permit this, it is going to incentivize the investigating authority to commit that illegality, they will say, oh, the person will get arrested, but we will get the evidences of our choice. Tomorrow we will say that the section statement was recorded and the statement is going to be admissible or the material is going to be admissible. So what I am doing is I am also, after the people are getting declared illegally arrested, I am saying that from the complaint filed by the ED subsequently, of which integral part is my client's statement recorded under section 50, I am saying either return the complaint or score off that portion where that statement portion has been used, because that is going to be the fruit of the poisonous spree, and I say that the means cannot justify the end. So
I want to know from you. I want to know from you two particular things. In this case, particularly after it has been held that the ED will supply you in writing mandatorily the grounds of arrest before you are arrested. There is another case, Vijay Madan Lal Chaudhary, which is being challenged in a review petition. What happens in that case? A, because ECIR is an issue, which is the enforcement case information report to be, if that the accused does not have, and he has the grounds of arrest, does he then not need the ECIR? Has that issue been solved, or the ECIR is still an issue that you as a lawyer in ED cases will say is a right of the accused? Or the grounds of... Could you explain and clear this confusion?
See, actually the problem is that when ED wants to call themselves to the police, they say we are police. When it does not suit them, they say that we are not the police. So on a lighter side, I say Kauwa chala hans ki chaal aur apni bhi bol gaya. So whenever they would want to be the police officer, they will become police officer. When they don't want to be police officer, they will say that no, we are not the police officer. So I see we have this, when Justice Deepak Mishra, when he was in Chief Justice Delhi High Court, he passed the judgment, and which became applicable to Delhi, that whenever you register FIR, it is to be loaded on the net within 24 hours. And when he became Chief Justice of India, he passed the judgment for whole of the India. Earlier it was to Delhi. For Youth Bar Association is the name of the judgment, that it will be informed. So when FIR is to be informed, why not ECIR? So what is ECIR? ECIR is just the copy cut paste of the FIR. But they say, no, it is like a case diary. We are not governed by section 154, though section 65 PMLA says that the provisions of CRPC applies to arrest, search, seizure, investigation, prosecution, what else the police does. So chapter 12 of CRPC is just the whole of it is covered in section 65 PMLA. So somehow this ECIR thing will also come, but the only problem is that in this review, because this money bill aspect is also being considered, whether the amendments can be made by way of a money bill. So I think, all these smaller issues of ECIR, the section 45 and everything, so that everything is going to get merged. So I don't know when are we going to see, though everyone is very hopeful, but I don't know when will this thing will see the light of the day. So in between, so we have to be satisfied whatever you get. So now we have to be satisfied with Pankaj Bansal and Batan Bansal's judgment. So I don't know when the review will come. So which I'm sure.
I want to know, I wrote of in many other cases, like you appeared for entry, other cases, for example, a person has been arrested, the grounds of arrest has been provided to him. So you will go and argue from in the court. But if you, as Advocate Vijay Agarwal, are successful in convincing the court that the grounds of arrest are not grave enough to merit an arrest, in your view, and the court is convinced, then the court goes into the rigors of section 45? Or what happens after that? Because does section 45 apply then?
See, section 45 will apply only if you seek bail. Here we are asking for a bigger relief. We are saying that the arrest itself is illegal. For that, section 5 is not applicable. See, section 45 will come. I say that, okay, I have been arrested, my lord. Please release me on bail. I will face trial. I am innocent. And there is a presumption of innocence in my favor. I am accused, not a convict. I am Muljim. I am not a Mujrim. I will face the trial. I will give my Google pin. I will go to the ED office. But please release me on bail. So no, that's not the case. The case here is, I say that at the first place, I ought not to be arrested at all. Like you recall my case in the Nirav Modi's case, one of his directors was arrested, a woman, she was arrested after the sunset by a male officer. So there is a division bench judgment in my favor by Justice Kathawala. He released the lady forthwith, the way Pankaj Bansal and Basan Bansal were released, and the CBI officer was fined 50,000 rupees to be deducted from his salary. They did not even dare to challenge the judgment in the Supreme Court. So that's the law. So in that event, the person is released forthwith, so there are no bail bonds given. Pankaj Bansal did not give any bail bond. Kavita Manikar did not give any bail bond. So the section 45 does not apply at all. And this judgment of there was first judgment Gautam Navlakha, which says that in case a judge remands you wrongly, then you can challenge the arrest, and then it is said by censor, and then now it is said by Pankaj Bansal, Basan Bansal, that the section 19 has rigors. This section 19 has to be satisfied, and they said because in section 45 has been upheld because initially the court has to take care whether section 19 is satisfied or not. That is why stringent bail condition is laid in 45. So if you don't comply with section 19, you will not graduate to the stage of section 45. So you can say that the section 19 is not satisfied. So that is why they were considered on the basis of santosh, that in case they say in the ground of arrest, oh, he is not cooperating in the investigation. So investigating agency will never be satisfied. I go there and hang the noose around my neck. So even then they will not be satisfied. They will walk over me and they'll say that why we are walking over Vijay Agarwal, but he is not smooth. So they will never be satisfied. So this is it. So section 19, in case it is the duty of the judge before his trial judge when the person is produced. But you know what happens is that the counsel has to take care. What we do is whenever a client is arrested, so the problem is the client is arrested and the engaging takes time, and by then the opportunity is lost. So the moment a client is arrested and is produced before the judge, one should file a lot of objections to the grant of remand and the objections to the arrest. So that if the judge passes a wrong order, then you can challenge it in the superior court or you can visit the judge himself. But the only problem is that the client reaches the lawyer later on when the moment he is arrested, he just fetches somebody and they appear in the court, and the court also gives the remand routinely thinking, oh, ED authority has come. So these judgments now very clearly say that this section 19 test has to be satisfied. And let me tell you, I saw the order in this Aam Aadmi Party suggesting that they have arrested. They have supplied ground of arrest because the arrest was just 1 or 2 days after this Basan Bansal, Pankaj Bansal judgment. They made it a point to supply the ground of arrest, and they have mailed it also. So now the investigating agency is taking care. So the clients who have been earlier arrested will get the benefit of Basan Bansal, Pankaj Bansal. ED is a great agency. Let me tell you, we've been dealing with EOW, we've been dealing with CBI, SFIO, GST. But permit me to say, if I have to compare ED's legal team and ED's legal officer, I mean, they are so thorough, they are updated with the law, and their panel is also, they have some great lawyer on their side. Generally, people believe that the great lawyers are on defense side. No, they have the great lawyers on their side. So ED is a very, very formidable opponent. So now, if you feel that in future such an opportunity is going to come that they will not furnish the ground of arrest. So for past arrest only we will have this, and this will fizzle off after a few days, because if in the new arrest this is not going to happen. So you are very right, Tarun, when you hit the bullseye, that you said that when they furnish those grounds of arrest, now the advocacy would be to find fault with those grounds of arrest and then say that the section 19 test is not satisfied.
One thing that all promoters would want to know, and if you could share with them, it will be valuable. Evasion or being evasive is used as, in a sense, an explanation for arresting a person. If a businessman is summoned by ED, does he have a right to say, I don't know, I don't remember, I choose not to answer? Then does that become a ground to arrest, or he is within his right to give these answers? Especially when it's a bank fraud, so the evidence may be documented. So these documents, the ED themselves can research and find out and investigate. B, if, for example, a promoter is called today, say October of 23 for questioning, and say he's asked for something which happened in 2016. Could you just explain it to the viewers? How does this work?
See, if I be hyper-technical, then he is protected under Article 20, Sub-Article 3, right against self-incrimination. They say, "Main chup rahungi, I will not speak." So this is it. He has a right of silence, right? And even if he exercises the right of silence, the adverse inference cannot be drawn against him. See, you are appearing before an investigating agency. When your trial starts in the court also has a right to put the questions to you under Section 313 CRPC. Even at that stage, you can choose to remain silent. And even if you choose to remain silent, adverse inference cannot be drawn against you. But practically, that would be hyper-technically, and you don't need professors, right? And you need lawyers who get you relief. So this is it. So, but practically, it so happens that you cannot, when you're sitting, it is very easy for me to sit in my office on screen with you and say, no, you will tell the officer, but please see, you are sitting in the ED office, you are sitting with a person of authority. So, and if you say this and he doesn't like you, so he can behave anything with you. He can behave anything, he can do anything. So there you have to sound convincing and tell the officer that this is the part I do not look after. This is a financial matter. I look after production, or I look after marketing, or I have a team of professionals. So I do not know about this. So Mr. X would know, or Mr. Y would know, or the person has left the company, or the person has expired. So you have to do the buck passing, which we all do. That if it's something we do not know, we will say that if it is our fault, we say that it is someone else's fault. So this is what. So you have to justify. Of course, you can say that I do not know, but then you will also say that I do not know. You please justify your saying so. So you have to lace it in chocolate and then serve the ED officer. So you will tell them that it is like this. So it is not because it is old, it is documentary, I do not remember, or it was looked after by X professional or Y professional or Z professional. So it is not something that is looked after by me, or I'll check, or I'll come back to you. And at this moment, or I am not in this state of mind also. So I cannot be giving you the answer. I cannot pull the rabbit out of the hat for you. So this is it. So that way you are well within the right. But please see, but what happens is, you please be very clear. You tell them everything. You tell them more than you know. Even then, they are going to call you with it. You don't tell anything. Even then, they are going to call you. It is their job. वो अपने हस्तिनापुर से बंधे हैं, हम अपने हस्तिनापुर से बंधे हैं. They have to call you evasive. Whatever you may do, they are going to call you evasive. It is their standard line. Now the law is in Santosh that even if you are not answering, that is no ground for arrest. You have to be, this expression, cooperation in investigation, is a misnomer. There is nothing called cooperation. I'm not supposed to incriminate my own self. I can refuse to give an answer. This is an age-old principle. It was settled long back that I can refuse to answer the question which I do not want to answer. So this is it. But people feel that, oh, if I go tell this to the officer, he will feel good, and he may not prosecute me. I've seen whatever you may say or may not say, right? I'm the bakra, they are the kasai. Even if I smile at them or I hit them, they are going to cut me. I'm very, very clear about this in the matter.
I want to ask you this: after this order in the Basant Bansal, Pankaj Bansal case, how many cases in your view will be impacted, which means people who have been arrested prior to this order and they have not been supplied with ground of arrest?
Whatever, they have not been supplying ground of arrest. They have been only informing, taking the signatures. All these cases will get impacted. But let me be very frank, there is one word used in the judgment, which is it uses henceforth. So when any lawyer is going to argue that I be given the benefit of Basant Bansal, Pankaj Bansal, they will say that the word is henceforth. But then you have to immediately show Madhu Lemie and other series of judgment that this judgment is only explaining. It is not lay down or rewriting the law that henceforth you would be giving. But you please see, it is said that the man proposes, God disposes. So Supreme Court wants to clarify the law, but the lawyers and the agencies and the various people will further create confusion. So now in this judgment, because of the use of the expression henceforth, it will again be debated everywhere. That whether it is only that case or it is applicable to all the cases.
So one thing for the viewer to know, if you could share, the Supreme Court via Justice A.S. Bopanna, Justice Sanjay Kumar has taken the law forward in a sense. Now the ED has to supply grounds of arrest. The other issues that remain to be addressed are Section 45 and ECIR. Could you make some observations on these two important issues?
Somehow I feel that ECIR they ought to be giving. It is nothing a state secret. Later on, see, when they attach, once I was arguing in Supreme Court, that time this judgment had not come. Justice Khanwilkar's judgment had not come. So that time the court kept the question open. So it was argued by the other side that, it keeps a secret information, my witnesses will get exposed, my informer will get exposed. And I said that they are arguing this, please let me show the ECIR, it is in my pocket. The court said, how come it is in your pocket? I said, when they pass the attachment order, when they pass the provisional attachment order, and when they file the complaint in the adjudicating authority, it is an annexure to that. So they gave it after, when they file the complaint, they give it after 60 days. So why can't you give it in 60 days? So it is an argument for the sake of the argument one. And see, this 45 can never survive. Somehow I find it very, very unfortunate that the three judges bench took the view, opposite the view taken by Justice Rohinton Nariman. So by no stretch of imagination, this thing is going to survive. So it is short-lived. But see, like now in 498 cases earlier, people were not getting bail. Now now I have not seen in the last few years anybody going to jail in 498A. So it is a trend. So all these, see, it is like this 45 is like Corona. So it will also die its own death. But
you're like law evolves, and
while it is at peak, it will take various people away with it.
One final question to you, Mr. Agarwal, for everybody to know. Section 45 which also impacts SFIO, which also impacts the cases involving drug running and all. This will be for everything, or this is only limited to money laundering?
The money laundering has a better case because the punishment is only 7 years. Please see, Arnesh Kumar and all these judgments, see, they say offense is grave. I say that the gravity will be determined by the length of the punishment. It is only a 7 years offense, like theft. Please see, I mean, they say that, it is graver than murder. So see, the offense against body, how can an offense against a property be graver than the offense against the body? So see, people will get a bail in rape, people will get a rape in murder, people will get a bail in attempt to murder, but they will not get the bail in PMLA. It is a joke. Please see, extortion, the offense is punishable with only 3 years. But you know, a person extorts the money and launders it and gives it to his family member. The family member will be arrested for 7 years and he will not get bail. But the person who committed the theft or committed the extortion, he will get bail. So we have to leave the common sense into the cold storage. So it is ridiculous. So sooner or later it will go. But as I said, that at the moment it is at its peak. So this is it. So you have to wear the mask and take care that the PMLA offense doesn't touch you. It doesn't come to your house.
Thank you so much for explaining this order of the Supreme Court in detail. Thank you also for sharing your insights on the other aspects of the Prevention of Money Laundering Act. We will request your time again after a few weeks on the review petition. Basically, a lot of people are interested in knowing what's going to happen. Of course, there are going to be a lot of arguments in court. We'll keep track of that. But would request your time then. But thank you so much for sharing information on the M3N Basant Bansal, Pankaj Bansal order, which you were part of. You presented them. This will go a long way and have an impact in many other cases. Looking forward to see you and speak to you. Until then, goodbye. Thank you so much for joining us.
Always a pleasure being with you. Thank you, Tarun. Thanks for having me.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.